Court calls case people versus Golam. Is it Gambari?
We open in a Michigan courtroom with Judge Simpson presiding, and right out of the gate, the stakes are high. This isn't a routine status check. This is a bond violation hearing. That means the defendant, Golam Gambari, is already out on bond and allegedly violated the court's trust. And what's the violation? A positive cocaine test. Not once. Twice. Now the defense is asking for an adjournment, arguing there's a hospital blood test from around October 1st that might show a different result. But here's the tension. They don't have it. No paperwork, no lab report, just the promise of a miracle test that could contradict two confirmed positives. Judge Simpson zeroes in immediately. If this hospital test could clear your name, why isn't it in court today? Why wasn't it obtained yesterday? In bond violation hearings, timing is everything. The court doesn't operate on maybe. It operates on evidence. And when someone says, just give me time, after two confirmed positives, then the credibility meter starts blinking red. So the big question becomes, is this a genuine mix-up or a last-minute scramble to avoid jail?
Good morning, Assistant Public Defender Lauren Prenny on behalf of Mr. Gambari. Mr. Gambari, please state your name for the record.
Golam Gambari.
We're here for a pretrial. Mr. Gambari also has a pending bond violation. I did get an updated report from Ms. Kerr today. Mr. Gambari is asking for an adjournment of the bond violation hearing. He did send out the test, and it did come back positive. However, he says around this time he did a test at the hospital. He takes narcotics for his some medical conditions that are prescribed. They do drug testing consistently there to ensure that he is taking them in accordance with therapeutic processes. And he reports to me that he believes that test that was done at the hospital would come back negative. He just has not received those results yet.
When is that test?
He says that test was around the time of October 1st. Is that right?
Yes.
So is he indicating there was a test that came back that the cocaine is a false positive?
He is.
Really?
He's saying that he did not consume cocaine, and he believes this other test will show.
So when that test was sent out, it came back positive.
Yes, they sent it for a review.
They sent it for a review, and it came back positive for cocaine.
Correct.
So now there's this other test that we're supposed to get, but we don't have the results that are going to show what?
He believes a different result than the test that was done at community
A
correction.
different result, like no cocaine?
Correct. He denies, Your Honor, that he consumed any cocaine. He denies that he consumed any cocaine. He does have a list of medications that he also tested positive for opiates. He does have a list of medications that he provided both to community corrections and to me that do include prescriptions for opiates. I know the court is more concerned about the cocaine as there's no medical reason to consume cocaine. But again, I can only report to the court that he maintains that he didn't use cocaine and he wants to prove it to the court using this other blood test. We've spoken quite a bit about this and he denies any use. He is asking that he not be remanded today. He again does want some more time. He has a eviction.
When was this blood test or this test at the hospital?
Oh, he was in the hospital around the time of October 1st. He has an after visit summary. He was at Trinity Health on October 1st at 10:30. On that date, he did testing. and saw his doctor for his medical needs.
And we don't have the test results back yet?
Yeah,
No.
When are they expected back?
just give me time. I can get it back.
He says he just needs time. He
When are they expected back?
do you know when they're coming back?
I can get it today, tomorrow.
Pardon?
I can get it today.
So you could have gotten it yesterday and then had it here.
I didn't know that. I have to bring it.
He says he well, I don't get into that. But Your Honor, he does want me to tell you that he does have a hearing on his an eviction proceeding hearing today. He is concerned that he's going to be evicted if he is remanded at this time.
No lease. I have to sign in my lease. No eviction.
Where do you live?
And 2993 Cascade Drive.
In Ann Arbor.
Yes. And I have to sign in my new lease. I don't have no eviction.
He doesn't have an eviction hearing
You have to sign-
because they do those on Tuesday.
Okay, I'm sorry.
Today's Wednesday.
I misunderstood. He has to sign his new lease
Yeah, I
today.
have to sign in new lease. At the same time, I have to be on a court today at 2:30 for I'm victim and for the accident, my damage, my property.
Oh, okay, I'm sorry. He is the alleged victim on another case at 2:30 today
I'm a victim.
Where?
for damage to his property. Wednesday, 2:30, before Judge Garwood, Magistrate Garwood. It is a small claim.
It's a small claims. It's a civil action. Okay.
So, Your Honor, again, he's asking for an adjournment.
But he could have had his
For more
test
time.
results. If you want me to wait for, he could have had him here today because he just has to get them from the hospital. But he didn't do that. And then he comes here in court to say that I'm going to see this miracle test saying that the cocaine wasn't there when we've already had two tests that say that the cocaine was there.
This is the turning point. Judge Simpson lays it out plainly. 2 tests already confirmed cocaine. The defense says there's another test out there that will somehow say otherwise. From a legal standpoint, bond conditions are strict liability in many respects. If the test is positive, the court doesn't need philosophical debates. The defendant is responsible for what's in his system unless there's clear medical justification. And as the judge points out, when there is no medical reason to consume cocaine, opiates, prescribed, that's documented. Cocaine, that's different territory. And here's what really hurts the defense. They admit the hospital results could have been obtained today. That undercuts the urgency of their argument. Courts look at diligence. If you knew this hearing was coming, why not walk in with proof? Judge Simpson is signaling that this sounds reactive, not proactive. Do you think the court should grant extra time based on a promised test result, or is that too risky when public safety and compliance are on the line?
Have I summed that up correctly?
Your Honor, I don't know if, I don't want to, this is my assumption is that Mr. Gambari was waiting to hear the results back from the sent out tests. Ms. Kerr did send up, I called her this morning and she said, oh, I didn't realize I had the results back. So perhaps he was waiting for those results to come back before getting the other tests because
Oh,
he maintains that he doesn't know where the cocaine is from.
okay. People.
Your Honor, this is an OWI second offense.
I know.
First offense is from 2018, and it involves a crash to a building.
You should, counsel, sign a release for you so you can get the test from the hospital. But at this point, the defendant's bond is revoked, defendant remanded to the jail. I'll adjourn this hearing to November 6, 2024, 9 a.m.
And there it is. Bond revoked. Remanded to jail. That means immediate custody. In bond violation cases, once a judge determines noncompliance, especially involving controlled substances, the court's patience narrows fast. The judge even offers a procedural safeguard. Defense counsel can sign a release to retrieve the hospital test results, so the door isn't completely shut. But for now, the court is prioritizing enforcement over speculation. Notice how the eviction argument and the small claims hearing didn't sway the decision. Judges weigh relevance. Housing concerns and civil disputes matter, but not more than a potential drug violation under bond supervision. This is a classic courtroom lesson. If you're asking for mercy, you walk in with documentation, not explanations. The hearing is adjourned to November 6th, which means there's still an opportunity to challenge the result. But for today, accountability wins. Was this strict justice, or exactly what bond conditions are designed to enforce?
I'll come see you for the next one.
Oh, yes, on that file. Very much. Good job.
Court calls the case People versus Michael Hartwell.
The tone shifts dramatically with the next case. Different defendant, different energy. Michael Hartwell appears physically vulnerable, explaining he was hospitalized for 6 months and believed his mother handled a licensing issue while he was incapacitated. Immediately, Judge Simpson adjusts his approach. Take your time. That matters. Courtrooms aren't one size fits all. This case revolves around a suspended license and a potential plea to double parking. Legally, driving with a suspended license can carry real consequences, but context is key. If the suspension stemmed from administrative confusion rather than willful disregard, prosecutors often exercise discretion. Notice the collaboration. Defense confirms license status, prosecutor has no objection, and the court verifies records before ruling. That's procedural fairness in action. Unlike the earlier case, this one hinges on documentation and verification, and once confirmed, the resolution moves swiftly. Should courts weigh personal hardship heavily in administrative violations, or should the rules remain rigid regardless of circumstance?
Oh, boy.
Okay, take your time. Take your time. Would it be easier for you to sit down?
Yeah, I would. man.
Okay,
I had a stroke,
okay.
Uh,
Take your time.
the thing about it was, my mother was supposed to have took care of me
Of this?
when I was in the hospital, and I didn't know if it was suspended.
Okay,
And then,
hold on,
oh,
hold on. We'll get to this. Okay.
Yeah.
What are we doing in this?
Yes, Your Honor, Assistant Public Defender Natalie Paywick on behalf of Mr. Hartwell. To my right, we are asking Mr. Hartwell believes his license is currently valid, Your Honor, and we are asking if
It is.
It is. Thank you. That he would like to take advantage of the potential offer made by Mr. Siller of double parking.
That is correct, Your Honor. Okay.
I thought they were gonna dismiss it because the license was not I paid for it. I thought they was gonna suspend it. I wanna fix it. I don't have money to be given out. I
Okay,
just paid out $200 and some dollars the other week, out of my, and then these supposed to pay another $180. I don't have that money all the time.
hang on a second.
Here's the
Okay.
thing right here. This shows how I paid it. I don't, that's it. I'm got money to pay off. All the time. Just moved up here. And I got a lot of things I have to take care of. So, anyway,
John, I'm just gonna move to dismiss.
Pardon?
He's got a valid license. You confirmed it. I'm just
You're
gonna
gonna move to dismiss?
I'm gonna move this.
Any objection?
Certainly no objection, Your Honor. Thank you. Thank you to both.
Sir, this case is dismissed.
thank you, Your Honor.
Dismissed. Just like that. The difference between the two cases is striking. In the first, missing documentation led to jail. In this one, confirmed records led to relief. That's the power of preparation and verification. Once the license status is confirmed and the prosecutor states no objection, the judge has legal room to dismiss. And what follows is something you don't always see: gratitude. Hartwell explains he couldn't walk for 6 months. He struggled just to get into the courtroom. From a legal perspective, this case demonstrates prosecutorial discretion and judicial compassion working together. Courts are not purely punitive machines. They are structured systems built around evidence. When evidence supports dismissal, justice can be swift and humane. But it's also a reminder: had that license truly been invalid, the outcome would likely have been different. Do you think this shows the system working properly, or does it highlight how much hinges on paperwork and timing?
I appreciate it. It's hard for me to get around. I have to have my vehicle because I can't. It had to come all the way down here to the last courtroom. I'm like, wow, I got to make it down there. And
Okay.
it was hard for me to get.
But you know what?
But thank you.
I'm so glad you made it down.
Thank you. I was in the hospital for 6 months. I couldn't walk until I got up, and I'm getting around now. And thank you very much.
You're welcome.
2 cases, 2 defendants, 2 very different outcomes, all under the same judge. In Gholam Gambari's case, confirmed positive cocaine tests during bond supervision led to immediate revocation and remand. The court emphasized accountability and the importance of bringing documented proof before asking for leniency. The hearing was adjourned, meaning the door remains open if new evidence emerges, but for now, compliance rules prevailed. In Michael Hartwell's case, the issue centered on a suspected license suspension during a period of hospitalization. Once records confirmed the license status and the prosecutor raised no objection, Judge Simpson dismissed the matter. The broader takeaway? Courts respond to evidence, preparation, and credibility. Promises don't carry the same weight as paperwork. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.